All right, let's get right into it. Today, we're heading into the Supreme Court of India to look at a case where a single, tiny fact in a government file wasn't just wrong, it was life-threatening. This isn't just about a legal argument. For the person involved, this is about survival.
I mean, just imagine this for a second. The very government that's supposed to protect you is denying you that protection. Why? Because of a mistake. A piece of paper somewhere says you never asked for help. Your life is in danger, and your only way out is to prove that one fact is just plain wrong. That's exactly where our petitioner finds themselves.
So, what's at the core of all this? It's Article 21 of the Indian Constitution. And look, this isn't just some fancy legal term. This is the bedrock promise of the right to life. The petitioner's whole point is that the state's factual error isn't just some small oversight. It's an active, ongoing violation of their most fundamental right.
So, picture the scene. Our petitioner, representing themselves, is standing before the highest court in the land. But right from the start, the court hits them with a question that could have shut the whole thing down before it even got started.
Wow. Okay, so that's a really tough question. The court is basically saying, hey, you already lost in the high court, so why are you here starting a whole new case under Article 32? Shouldn't you just be appealing the old one with an SLP? It's kind of like a procedural checkmate, and everything, depends on how the petitioner answers this.
But here's the thing. The petitioner saw this coming. They came armed with a brilliant and pretty unconventional strategy. They knew a normal appeal was a dead end, so they picked a completely different and way more powerful constitutional road. And this is where it gets really clever. An SLP is all about telling the Supreme Court that a lower court got the law wrong. But an Article 32 petition, that's a totally different beast. That's you going directly to the Supreme Court and saying, my fundamental rights are being violated right now. You see the difference? The petitioner isn't arguing about a past decision. They're fighting a present, ongoing injury.
And that is the masterstroke of a response. The petitioner makes it crystal clear. I'm not here to argue about the high court's legal logic. I'm here because the government, today, is using a factual mistake from that old case to violate my right to life. It's not an appeal, it's a constitutional emergency.
Okay, so with that procedural trap avoided, the case gets stripped down to its absolute essence. This is no longer some complex debate over legal precedents. Now it's just a fight over one simple, verifiable fact.
And this is it. This is the single incorrect statement the whole case is built on. The government and the high court before were all working from the assumption that the petitioner never actually went to the police to ask for protection. That one sentence is their justification for doing nothing.
So now the court puts them on the spot. It's a direct challenge. The state says you didn't do it. The court records say you didn't do it. So prove it. Show us the proof. The burden is now squarely on the petitioner.
And this is that moment of truth. The petitioner needs what lawyers always hope for. That one piece of evidence, that smoking gun, that can just blow the other side's entire case to pieces.
I mean, can you just imagine the tension in that room? The petitioner's safety, their credibility, their entire case. It all came down to the one document they were about to present.
And there it is, Annexure P6. This isn't just a letter. It is an official police diary entry, number 4045/S/SSP. It's got the stamp, the date, everything. It proves, without a shadow of a doubt, that the petitioner's request for protection was officially received by the police on June 18, 2025. Just like that, the state's entire factual foundation completely crumbles.
So once that factual error is out in the open, the whole dynamic of the case just flips. The petitioner is no longer on the defense. Now they're demanding a remedy, and they're demanding it now.
And you can just hear the shift in the court's tone. The skepticism is gone. They're convinced. They're now asking the petitioner, okay, you've proved your point. Tell us what you need us to do to fix this, right now.
And the petitioner's request is just so simple and logical. First, just have the court acknowledge that the state's fact was wrong. Second, order the state to provide protection immediately, based on their own official records. And third, make sure their right to life under Article 21 is safe while the rest of the case moves forward. It's a perfect straight line from evidence to remedy.
So, what does a case like this really teach us? Well, it's a huge reminder that Article 32 isn't some abstract idea. It's a real-world tool for citizens when their rights are violated. It proves that factual accuracy isn't just some minor detail. It is the absolute bedrock of justice. And maybe the most powerful lesson of all,
It shows that one person armed with the truth can absolutely hold the state accountable.
And that really leaves us with one final, kind of chilling thought. This petitioner was able to find the single error that put their life at risk. But it just makes you wonder, how many other critical decisions in courtrooms, in government offices, maybe even in our own lives, are made every single day based on one little fact that nobody ever bothered to double check?